All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good afternoon, everyone. Mr. Jena, you still have the floor. Microphone, please.
Yeah, good afternoon again, Mr. President and Your Honors. Your Honors, the trial chamber, having found Mr. Ongwen responsible as an indirect co-perpetrator, should find this a mitigating factor from the perspective of his individual circumstances. Given that he was, for all purpose and intent, just carrying out orders from above in compliance with the laid down LRA policies, there's no reason why this should not, whatever the manner and nature of his conduct, constitute individual mitigating circumstances for him. Talking about Mr. Ongwen's conduct, Your Honors, I have to remember to thank him for protecting my life. There's the conduct of a person who, against all odds, could even dare Mr. Joseph Coyne. But, Your Honors, this should not be taken in abstract. Should be considered from the perspective of what processes were going on in the minds of Mr. Ongwen at the time he did this. Ongwen mentioned himself this morning that he had adopted suicidal tendencies at that time, that during those moments when he went to battle, and those moments which people have isolated out for his being very brave, were moments when he had hoped that he would die anyway. So this should be seen as somebody who had a substantial problem with his mental capacity. And together with this, Your Honors may remember that some people said, some witnesses testified before this court, saying that there were moments in Ongwen's character when he would feel very detached. He would be very quiet. And there are these moments which the victims and prosecution talked about, when he would be kind, and then another time he was this and this was. These are the tendencies, hallmarks of PTSD, as described before this court by the experts who gave evidence before this court. If these were truly the findings which the prosecution and the victims seem to agree with, then there is a clear line of evidence indicating that indeed, at the time of the convicted conduct, and far beyond it, Mr. Ongwen was suffering from suppressed mental capacity. And this also extends to duress. You know, his belief in Coin's spiritualism, which he again emphasized to your honors this morning, were all signs that the man was always acting. At any moment, he was acting under duress, save for those moments when he gave himself up and said, come what may, what will be, will be. And it took those daring, suicidal confrontations with the enemy, including Coin himself. The prosecution recommends that the chamber should enter separate sentences for each separate crimes, reflecting the particular harm inflicted by conscripting a child into an armed force by coercion or compulsion, and by using that child to participate actively in hostilities. Your Honors, to say the least, this is very insensitive to the fact that Mr. Ongwen was, in the first place, a victim in the same manner and had been through, and by his personal experiences, learned what he was expected to do in such circumstances. Your Honors, for those who are dog owners, know that a dog will act according to how it's taught. Children in the position of Mr. Ongwen were reduced to the level of dogs who just took instructions without thinking about repercussions. And we talk about lawfulness. Your Honors may have to pause a bit again and reflect about which law were we talking about when we are talking about the unlawful conduct of Mr. Ongwen. Granted, this court may have found otherwise, but isn't it true, Mr. President and Your Honors, that the circumstance under which Dominic Ongwen was abducted at the age of 9 and never allowed to relate or interface with the open society did not afford him the opportunity to know what is the law of the country, international law, and so on and so forth. To him, the law was that which was taught to him by Joseph Coin. The Ten Commandments as interpreted by Joseph Coin. So when he was ordered, he turned to no more than the law of Joseph Coin. All these factors, Your Honors, should be compelling enough for you to consider that, well, yes, we found him guilty because of the high threshold of international criminal law standard of proof. But as a matter of fact, these circumstances nevertheless existed and should be given weight. Mr. President, the defense seriously objects to the analogy which was made by Mr. Maloba, comparing the individual circumstances of Mr. Ongwen, addressed by the prosecutor, to a supposed fundamentalist Muslim war criminal. The submission is entirely inappropriate and should be disregarded. There was absolutely no legal basis for such analogy. Your Honors, unlike the child recruit, who is firstly a Muslim religion believer, who normally voluntarily joins fundamentalist groups, sometimes out of conviction, sometimes because of the monetary inducements attached to them, or at the extreme, because of a promise to go to heaven. Dominic Ongwen was forcefully abducted and conscripted into the LRA ranks against his will. How does it compare to a fundamentalist? The analogy was therefore totally unwarranted and unfortunate and should be disregarded. Ongwen was a victim of circumstances beyond his control, unlike recruits of Muslim fundamentalist movements. The victims have recommended imprisonment for life, but have provided no legal basis on how that sentence was calculated, apart from emphasizing the brutality of the crimes. Your Honors we will respectfully be reminded that that factor was already taken into consideration by the Chamber in the conviction of Mr. Ongwen. To do it again, Your Honors, would amount to double counting. By acknowledging, though, what they have said, in effect, counsel for the CLRV acknowledges that the Chamber took the gravity of the crimes against the victims when convicting Dominic Ongwen. The Chamber read out the names of individual victims per crime base, and per crime committed, and emphasized the specific features of the injury or harm suffered. The jurisprudence of international courts and tribunals do not allow double counting. By relying on the same factors in conviction and sentencing, Your Honors will find these decisions in the case of Lubanga Trial Chamber decision on sentence of the 10th July 2012 at paragraph 35, of the Bemba case Trial Chamber decision sentence 21st June 2016 at paragraph 14, Al-Mahdi case Trial Chamber judgment and sentence 27 September 2016 at paragraph 70, Ntaganda case Trial Chamber sentencing judgment 7th November 2019 at paragraph 13. Mr. Chairman, this reminds me about what Mr. Maloba said yesterday. I don't know whether he said it consciously or unconsciously. He was talking about conviction of Al-Hassan for 10 years. Unless I slumbered and I did not know what has been going on in these courts, I am not aware that Al-Hassan has been convicted. And I'm not even aware that there has been any conviction in this court for 10 years. So, Your Honors, maybe you would safely disregard that submission of Mr. Maloba as misguided or misinformed. Mr. President and Your Honors, where the discriminatory intent was considered as part of the common plan and thus the mode of liability, it would not be considered separately as an aggravating circumstance. This was again the finding, the decision in the Ntaganda case, trial chamber sentencing judgment of 7th November 2019 at paragraphs 125, 151, and 169. I will now talk about the mental health of Mr. Ongwen. The prosecution and victims yesterday argued that there is no evidence on record to suggest that Dominic Ongwen did suffer from substantially diminished mental capacity during the charged period to warrant it being considered as a mitigating factor as per Rule 145.2A1 of the Rules of Procedure. They further stated that the evidence of various witnesses testified that they did not notice any mental problems in him whilst in the bush. Your Honors, D41 and D42 testified that as a direct consequence of his experiences in the bush, Mr. Ongwen suffered from multiple psychiatric disorders that included post-traumatic stress disorder, major depressive disorder, dissociated amnesia, dissociative identity disorder, DID, obsessive compulsive disorder, OCD, and suicidal ideation. Mr. President, I've already made references, especially about suicidal ideation. This was very evident in Mr. Ongwen's own testimony. Mr. Ongwen looks at the world in a different way we look at the world, the way he was saying it. That underlies the fact that the man is sick. He doesn't look at the world the way you and I look at it. For him, the world has left him behind. In fact, he belongs to a different world, and that different world, for those of us he has been discussing with us, is a place with God. And every time we've had occasion to discuss some of those suicidal tendencies, which is attempted on several occasions, this is what he tells us. And yet he loves life. And yet he loves his children. He loves his family. Why would you say this? Save for the fact that he's mentally depressed. The only mental illnesses that ordinary people, according to D41 and D42, they stated the only mental illnesses that ordinary people can recognize easily are those involving the brain substance directly, such as dementia, brain infection, the aftermath of brain trauma as a result of traumatic injury to the skull, as well as psychotic conditions that manifest with hallucinations, seeing or hearing non-existent objects, delusions, false beliefs and convictions that are not shared by members of the sick person's social groups and irrational behavior. Referring to his conduct in the bush as reckless, as reckless, at least two witnesses we interviewed claimed that Mr. Ongwen's behavior and conduct was more than just being brave, indicating that there was something irrational with the behavior of Mr. Ongwen that his close friends noticed on occasions. Mr. President, and Your Honors, you will agree with me that is directly opposed to the proposition of the prosecution and the victims that, as a matter of fact, nobody ever mentioned anything about, funny things Ongwen was doing. But even if that was true, a psychiatric expert at the highest educational level attainable, and a well-honored professor of psychiatry, said, it is not for common men to discern some of these features. Many of these features can only be discerned by experts. For you and me, we can only see the obvious things which they described. So therefore, it is our fervent submission, Mr. President and Your Honors, that you may be pleased to reconsider this matter, although they were not worthy of a finding that he was not criminally liable. Nevertheless, it should be found that his capacity, mental capacity, was substantially diminished. Mr. Ongwen has himself stated this morning that what people considered in him as bravery was suicidal attempts. He was tired of living dog's life. So every time he went to war, he defied all conventional wisdom of keeping safe distance from enemy fire. His hope was always that he would, like many of his deceased peers, die and end it there. Mr. President and Your Honors, this is not the thinking of a mentally alert person. This is deranged. Somebody who might have wanted to throw himself into fire or into hot water. That's a madman, at least at that time when he was taking this decision. And these moments included the period, included the convicted period. That was a description of his conduct at the peak of what he has been charged and convicted of. Your Honors, Professor Vuga, as a licensed physician, discovered the mental health condition of Dr. Ongwen, of Dominic Ongwen, while examining him for his expert report. He was mandated by his professional oath and ethical duty to provide him medical assistance. That does not make him the treating physician, nor alter his position as an expert. Besides, his conclusions about the effect of spiritualism, indoctrination, were corroborated by the ICC detention physician notes, tying his present mental health disability to the traumas he suffered from his abduction and continuing to date. Mr. President, and Your Honors, maybe I should again take it from what Mr. Ongwen said this morning, that the defense team is overly gratified by the bold decision by you to allow for psychiatric and psychological support and treatment for Mr. Ongwen. We are proud that the man we could not risk to come and testify before court about 3 years ago has now come of age. At that time, as far as we were concerned, he was still a child in the mind. We assessed his capacity to come and be here and talk to you, talk to court in a responsible manner, and found that he could not. But at the end, after serious assessment, we found that this is a now completely brand new Mr. Ongwen. You heard him this morning. I made my own impressions, but I'm sure you too made your impressions about Mr. Ongwen. If only you could detect the way he was conducting himself here at the beginning of the trial, and the person now before you, you will agree with me that yes, there was a problem before he attained the medical attention that was given to him in prison. And Mr. President, and Your Honors, the prosecution further downplayed the findings of the court-appointed Professor De Hyong, the expert who, after examination of the convict, concluded that he suffers from mental illness, among which include PTSD. You may be reminded that you acknowledge Mr. Ongwen's present mental health, disability, and suicide ideation, and took measures during which, during the trial, to accommodate his needs by inter alia altering the sitting schedule. It is thus our submission that this aspect should be considered as a mitigating circumstance for Mr. Ongwen. Again, referring, if I may, back to Mr. Ongwen's conduct. Your Honors may do your own findings from records from the prison that Mr. Ongwen, among the prisoners, is one of the most loved by every inmate in prison, save for the few occasions when he was provoked. And those few occasions, unfortunately, according to our own assessment, and perhaps assessment of the prison officials, was triggered easily because of his health condition, because of his mental health condition. But, and of course, you saw one such thing in court here. A sick man of his type is extremely sensitive. The way he behaved in court at the hearing that one of the witnesses who was testifying before this court could have been responsible for the death of his brother will tell you that, at least at that time, Mr. Ongwen was not normal. But a lot of sensitive things were said here. yesterday, and he responded to some of them, especially regarding incriminating his entire clan by Mr. Manoba, who he refers to as agent provocateur. He was still cool about it when has come of age. And this should be taken and put on his credit side. Mr. President, I shall talk about
You're cognizant of the time.
pardon?
You're cognizant of the time.
Oh, 10 minutes. I shall have
Okay,
finished.
good.
Shall have finished. A false impression has been created by the victims that Dominic Ongwen never attempted to escape. He has already spoken about this, and I do not need to repeat. But save for the emphasis that, they downplayed attempt to escape by contacting General Salim Saleh. It was very unfortunate. It would take a madman, and he talked about it. That is a distinctive fact that shows that Ongwen was willing to go all out to escape. I mean, reaching for those who know the terrain of politics in Uganda. It takes a very brave man, a determined person, to reach the level of a general of Salim Saleh's standing. In response to paragraph 2 of the victim's statement, the defense submits that the framework for sentencing provided for under Article 78 of the Ram Statute should be interpreted in the context of other related provisions of the relevant laws. Again, at the risk of being misunderstood for wanting to litigate the defense of duress, which was rejected by the Chamber, it behoves us to reiterate to the Chamber the provisions of Rule 145(2)(a)(1), to the effect that at the time of the conduct for which he has been charged, nevertheless, there existed circumstances which just fell short of finding of diminished mental capacity or duress, which otherwise constitute grounds for exclusion of criminal responsibility. In paragraph 5 of our same opening statement, the prosecution said the evidence of many of the child victims in this case could, in other circumstances, be the story of the accused himself. The evidence makes it plain that he could be kind. One prosecution witness has told the court that General Dominic Ongwen was a good man who would play and joke with the boys under his command and was loved by everyone. In other words, what those child victim soldiers, witnesses are saying is a lamentation, Mr. President and Your Honor, that had it not been for his individual circumstances, Dominic Ongwen would not have committed the crimes for which he has been convicted. This surely cannot go unnoticed by the Chamber as a mitigating factor when considering appropriate sentence for Mr. Ongwen. The defense respectfully invites the Chamber to consider the assessments of medical history of Mr. Ongwen, as already stated. In respect to consideration, inter alia, of the extent of the damage caused, in particular the harm caused to the victims and their families, we would respectfully ask the Chamber to refer back to what we have stated about the policy directives of the LRA. He did it under, on the orders based on those policies. While considering the nature of the unlawful behavior and the means employed to execute the crime, the degree of participation of Mr. Ongwen, the degree of his tent, the circumstances of manner, time, and location, and his age, education, social and economic condition of Mr. Ongwen, the chamber should take into account all the things we have already alluded to. The defense position in sentencing consideration is that Mr. Ongwen Dominic has overstayed, I repeat, he has overstayed his hospitality in captivity. 27 years in Joseph Coyne's prison without walls, and more than 6 years at the court's detention center as a result of this chamber's order. That is a total of more than 33 years of imprisonment. Under Article 77A of the Rome Statute, the maximum sentence a convict can serve is 30 years. Mr. Ongwen has already been in prison for 3 years, more than what this court is permitted to render. He must be set free to go home and participate in the actually traditional rituals, to have a holistic rehabilitation. Therefore, Your Honors, as I conclude, we are asking that, notwithstanding what we stated in our closing brief, on further consideration, especially when I arrived in The Hague and convened with my staff, we considered that all circumstances considered, Your Lordships can weigh the individual, should weigh the individual circumstances of Mr. Ongwen. Think about his children. Think about the family at home. And I'm sure, as members of the international community, your ears are on the ground on what is happening in Uganda, on what the international community is saying about this. The international community, like I do, together with my team, totally agree that you had the right to come to the decision you took, because it is about your finding. If we want to appeal, it is now a new ball game. And I am totally surprised that the intention to appeal should go on the debit side of Mr. Ongwen for being unapologetic, and therefore is not, you know, Mr. President and Your Honors, I am sure members of the legal fraternity are aware that appeal is a right, and that appeal does not in any case, in any way, militate against or undermine the decision of the lower court. It is only exercised in view of the fact that there might be certain things that the lower court may not have seen. And therefore, since the law allows the convict a further appeal to a higher court, it is only right that he goes there. So this submission of Mr. Masida, Madame Masida, I think should be seen in its context and should get disregarded. We also take last, absolutely last, we take exception to the way the Victims' Council have treated the Mataput institution. This is very unfortunate, because it would appear to confirm that councils have been actually making statements from the bar because they're not in touch with the traditional systems, not only in Acholi, but in the entire African context. Because to say that because Matoput is only a practice in Acholi, it cannot apply to Lango, it cannot apply to Teso, it means somebody does not understand, actually, the cross-cutting application of these systems. Just like in marriage, if you go to marry in Acholi, I'm a Lango. If somebody is a Lango, you are going to marry in Acholi, you don't carry your Lango custom to Acholi. You go and comply with the Acholi customary norms for that marriage. By the same token, Matoput is exercised in the same way. Mr. President and your honors, my defense team and I are exceedingly grateful for the very professional guidance you have given to this court. And we say this without any pretense at all. The way you have guided this court, in my view, I shall sing it on the rooftops, regardless of the convictions that our client has got. I want to thank you again. May God bless you. Thank you very much.
Thank you, Mr. Ayena. This concludes the oral presentation by the participants. The Chamber reiterates that no written request for responses or reply to these oral submissions will be entertained. The present hearing is closed. The Chamber will now retire to deliberate. It will render the sentence with the reasoning on Thursday, 6th May at 11 o'clock. And of course, here in the courtroom with a summary of the reasoning. This concludes the hearing on sentence under Article 76 of the statute. The court is adjourned.
All rise. Veuillez vous lever.